Hello everyone, welcome to the new video on 3-minute series for prelims. In this video and in a coming few videos, we'll be discussing about the importance and the powers and regulations of the Supreme Court of India. Supreme Court was inaugurated on the 28th of January 1950, that is after the Constitution has entered into force on 26th of January 1950. It replaced the British Privy Council as the highest court of appeal and also succeeded the Federal Court of India, which was established through the Government of India Act of 1935. Articles 124 to 147 deal with the organization, independence, jurisdiction, powers, procedures of the Supreme Court. The Supreme Court consists of originally of one Chief Justice and 7 other judges, but currently there are about 34 judges. This includes one Chief Justice of India and about 33 Supreme Court judges. The number of judges of the Supreme Court can be increased only by the Parliament through an act called as the Supreme Court Number of Judges Amendment Act of 2019. This number has been increased only in 2019. Earlier, the total number of the strength was only 31 judges, including the Chief Justice of India. And the process of appointment of judges of the Supreme Court is guided through the third judge's case, where the Chief Justice, along with the 4 other senior-most judges of the Supreme Court, has to propose a name to the President to appoint him as the judge of the Supreme Court. This can be done only with the approval of all the 4 members or a majority of the 4 members. Suppose if 2 of the Supreme Court judges decline the person as a candidate to the judge of the Supreme Court, then the Chief Justice of India should not recommend that name to the President. Therefore, the ultimate authority and the independence of the Supreme Court lies with the judges itself, and this ensures that there is separation of powers between the executive and the judiciary, where the judiciary is not influenced by the directions or authority of the executive. The Chief Justice of India is appointed by the President, who is generally the senior-most judge in the Supreme Court. The normal process followed is the outgoing Chief Justice of India recommends the next senior-most judge of the Supreme Court to the President to appoint him as the Chief Justice of India. And then he will be appointed by the President as the Chief Justice of India. The qualifications for becoming a judge of a Supreme Court are: he should be a citizen of India, and he should be a judge of a High Court or a High Courts in succession for at least 5 years, or he should have been an advocate of a High Court or High Courts in succession for 10 years, or he should be a distinguished jurist in the opinion of the President. For prelims perspective, so far no judge has been appointed through the last provision, that is on the provision of distinguished jurist. All the judges so far have been appointed either through the second principle or the third principle only. The tenure of the Supreme Court judges is they can work till the age of 65 years, or they can resign in between by tendering their resignation to the President of India, or they can be removed from the office by the President on the recommendation of the Parliament. We will look into the removal process of the judges of the Supreme Court and also the Chief Justice of India in our next coming video. Now let us solve this question. Consider the following statement: Supreme Court of India is the highest court of appeal in India. Chief Justice of India is appointed by the Prime Minister on the recommendation of the Union Law Minister. The correct answer is A1 only. We have seen that the Chief Justice of India is appointed by the President and not the Prime Minister. Therefore, statement 2 is wrong. Statement 1 is correct because there is no other court above the Supreme Court for the appeals of the lower courts. Therefore, Supreme Court in India is considered as one of the highest court of appeal. Thank you.